Hi, everyone. Hope everybody's having a good afternoon. We're now live. I am Stephanie Hunnell from the Hunnell Law Group, a boutique law firm in Asbury Park, New Jersey, where we help families through life's transitions. So that's divorce, family law, probate, and real estate. And I'm here with Adelola Dow and Rebecca Levin. If you two ladies would like to introduce yourselves first.
Sure. My name is Adelola Dow, and I am a divorce and family law attorney in Staten Island, New York. My law firm is the law offices of Adelola Dow, where we help you turn fear into power, where happiness fades away. Rebecca?
Yes, hi, I'm Rebecca Levin. I'm an attorney at Journer Law Group. We're based out of Philadelphia. We serve the surrounding counties in Philadelphia as well as go into South Jersey. I practice there matrimonial law. I also have an adoption and assisted reproduction practice.
So this is our fourth week coming to you live for Tri-State Thursdays, and I love this segment that we're doing, not only because we get to talk about family law, but we also get to apply it to what's going on currently with COVID-19 and how that's impacted some family law concepts. But today I'm especially excited because we also, in addition to our opinions as attorneys, we also have a special guest to talk to us today, and that's Mark Bradford. He's a CPA, CFE, and a principal at Asterion. Mark, would you like to introduce yourself?
Hi, Mark Bradford. I'm a forensic accountant, CPA. I primarily specialize in divorce litigation consulting. We cover Pennsylvania and New Jersey. We have several people that do that cover Jersey and PA. And we also get into bankruptcy restructuring. We value intellectual property and businesses and do all kinds of great stuff. We're not a CPA firm, but we just strictly do litigation. We're all former big CPA people that move into different areas. We all have our little niche.
Awesome. Welcome, Mark. I'm glad you were able to join us. So we are going to be talking this week about asset valuation during the divorce process, and specifically how and if those values have been impacted either currently by COVID-19 and the stay-at-home orders, or if we think they might be impacted in the future, and what it all means, which is why we brought Mark on to talk about some of those financial aspects. But before we get into kind of the nuts and bolts of that, I think it's important for us to define what we're looking at as far as assets. So Ade, what type of property is potentially subject to distribution during the course of a divorce?
So in the state of New York, there is a presumption that anything you acquired during your marriage, from the date you say I do to the date somebody files a complaint, or in New York, a summons with notice for divorce. So everything in that you've gotten in that time period is presumed to be marital. Now, there are some exceptions, such as personal injury awards, inheritances, gifts that you have received from third parties, and also an exception is any kind of appreciation in value of an asset that you may have had when you said, I do. If that asset was separate when you said I do, and the appreciation is something called passive appreciation, which we'll get into later on, that appreciation is going to belong to the spouse who had the asset in their name when you got married. So there's a little caveat to that, which we can discuss as we get more into the matter of our discussions, but that's the general lay of the land for New York.
And how does that differ in Pennsylvania, Rebecca? If at all?
Yes. Well, our definition of marital property is largely similar, with one very big difference. So marital property is generally property acquired from the date of marriage to the date of separation, plus, and this is where the difference is, increase in value on separate or premarital property. And so, for example, one example I gave is, say you had a 401k account. You had it before you came into the marriage. You didn't put any money into it during the marriage and it continued to go up, that increase, the difference between what it was date of marriage to date of separation, is considered marital, unlike what Adelola was saying in New York. And so that is a big difference. Certainly we have largely some of the same exceptions. For example, a gift to one of the spouses during a marriage or inheritance to one person is non-marital so long as it's not commingled. But again, from the date that you receive that to the date of separation, the increase in value is marital. And certainly, and this could be very relevant today, it's actually valued from either the date of separation, or if there's a time lag between when you separate and when the divorce goes through, and that asset goes down in value to when it's finally distributed, it's the lesser value of the two. So if you at the date of separation had an account that was $10,000 and now it's going down, the economy's going down, then and now it's $8,000, we're going to use $8,000. So that's a brief summary. And Stephanie, tell us about New Jersey.
So in New Jersey, like you were saying, it's actually a little bit different. So it's date of complaint, the date of the marriage to the date of complaint is considered the marital coverture portion, which we kind of loosely define as the marital property, how we determine what marital property is. There was a lot of litigation previously about separation and whether we can use separation, and the courts have determined now that it really needs to be the date of complaint, because we need to have an affirmative date when we know parties are separated, because parties can reconcile just because they move away. So there was a long list of cases that have resolved that issue. So absent, there's some exceptional circumstances, but it is from date of complaint, date of marriage to date of complaint is what we're going to use for the value of marital property. And all marital property is subject to distribution in New Jersey. But it's not all treated equally. So, and we'll talk a little bit about that when we talk about some active and passive assets.
Rebecca, is PA an equitable distribution state?
Yes, Pennsylvania is an equitable distribution state.
Yeah, so New York and New Jersey are as well. And so when we talk about equitable distribution, it's really important, as Stephanie just hinted at, to make sure that everyone understands that it's equitable distribution is not tantamount to equal distribution. The longer you're married in New York, and I believe the same thing in New Jersey, the more likely it is that certain assets such as equity in houses, et cetera, are going to be split 50-50. And we have case law in both states that deal with that. But that doesn't mean that it has to be equal. Even if you're married for a long time, it's really probably going to depend upon the type of asset, such as businesses.
Yep. I guess you gave a really good definition already of equitable distribution, and that really applies for all three states. There's, when we're talking about the distribution of assets, though, there's also, all assets are not the same. So we're talking about businesses, we have 401ks, we have houses, we have so many things that we have to distribute during the course of a divorce. And there's something called an active asset, and then there's something called a passive asset. And it might not mean as much in Pennsylvania from what I'm understanding from Rebecca's prior comment, but in New Jersey, at least, if you have a passive asset, which means an asset that is increasing in value only as a result of like market forces, for example. So if you have a 401k and you owned that premaritally, and it's increasing in value during the course of the marriage, but you have not contributed a single dollar to that account, then that would be considered a passive asset and it would not be subject to distribution. That very same 401k, if you now started earning money during the course of the marriage and putting money into it, it becomes an active asset and you can subject to distribution. Not all of it, but the part that accumulated during the marriage that can be considered an active asset and subject to distribution. And again, it doesn't necessarily have to be an equal amount. It doesn't necessarily have to be a dollar for dollar amount that goes into it. There's a lot of arguments and gray area in between that we as attorneys have to go through to figure out what is distributable and what is not distributable. I wanted to just mention, so just to give some examples of Oh no, I'm moving on to the next thing. Nope, go ahead. Ade, do you have anything to say about the active and passive assets?
Right. So New York deals with property, for instance, a 401k. You mentioned that in exactly the same way. If you never contributed to that account during your marriage, that account is not going to be subject to equitable distribution. Neither the account nor the account gains will be subject to equitable distribution. However, if you put money in, then our cutoff date for you is going to be the date of complaint, but our start off date is going to be the date of marriage, and any kind of appreciation that has been enjoyed by the monies that you put into the account during the marriage. Now, if you have a home, for instance, in the state of New York, even though the house itself, let's say that I had a home before I married my husband, and my husband and I lived together in that house as our marital home. Anything that I enjoy an appreciation that just happens because time goes by and properties get more expensive is mine to keep. However, if we now start ripping down walls and we start getting new kitchens and new balconies and things like that, and those things cause an increase in the value of my house, my spouse can look to share in that increase. And if that person can show that they actively participated in selecting the paint and picking out the cabinets and talking to the contractors, then that person's going to have that increase be on their column, at least a half of it.
Yeah, I have a comment to add and also a question for the two of you. So one comment is we've been talking a lot about assets, but I would say that equitable distribution applies to debts as well.
Yes.
So marital debt is included in the calculation. But a question for the two of you is you made note that the assets are valued from the date of a complaint. Now, in today's economy where things might, are going down, accounts are losing value, is there an adjustment for that in your equitable distribution?
Well, Stephanie, if you want to. So the assets aren't valued as of the date of the complaint. It's just that that's the point in time when marital assets cease to accrue, right? And so
okay, and that's the same. I had misunderstood the interpretation. So you will still value it at the closest to the date of distribution.
yes, or the date of trial, whichever one.
Well, I think it depends also. So if we're looking at a value of an account, let's say it's something that we can tangibly say as of the date of complaint was worth X dollars. They're going to use that value, I think, unless it goes down, because there's some argument about distribution dates and that kind of a thing. But, we kind of try to get values as close to the date of complaint as we can, with the understanding that certain types of accounts are distributed later. So there's the plus column and the minus column that both parties are going to have to take equal responsibility for. So that happens with stocks and 401ks and those kind of things. And maybe Mark can talk a little bit about this also, but looking at those types of accounts in economies that are less than stable, I'm going to call our economy right now because it's up and down constantly, I would probably be recommending, or you were looking at these things as an in-kind transfer and not necessarily at a dollar amount. So maybe splitting up accounts like 401k, sometimes we try to equalize them. Maybe now we might not do that. I lost everybody for a second.
Yeah, you cut out
froze
a little bit. Yeah.
All the screens went black, so I apologize.
Okay, looks like you're there now.
Yeah, we can see you.
Okay, good. So I was just talking about doing in-kind transfers instead of focusing so much on the actual values in uncertain times.
Right. And
are you seeing that?
And I think that can be a challenge based
Mark?
on the.
Oh, I mean, we do a mixture of things, but in economies like this, when you have an individual with significant financial assets that are out in the market in a 401k or an IRA or other things, my general advice to people is let's wait till things calm down. When you have the market swinging 2 to 3% a day, Yeah, I laugh because in January I kind of cautioned somebody to slow down on something because we swung like 1% in a day, and I thought that was like catastrophic. Now we're seeing like 10% or 5%, and it's just like it's nowhere near. But it just shows how crazy the times are right now with things. And I with people with substantial assets like that, I have told them to kind of let's just back off and wait a little while. Because I don't want to swing one way and hurt you, and it just not be fair. Because if I do a report today and we get together 2 weeks from then for the discussions on equitable distribution and things are wildly different, well, why did I do the report? Back in the day, 6 months ago, things didn't do that, and you could pretty much hold steady. It's a little bit different now. Now, I know what you were talking about before with timing, businesses in New Jersey, you value businesses at the date of complaint. And that's pretty much how it holds, where in Pennsylvania, we carry it through to date of distribution. You try to value it as close as possible. But there are cases in New Jersey that say if something catastrophic happens outside the business owner's control, you can bring it forward and adjust that amount if needed. There are a couple court cases out there that have stipulated that it used to be a hard battle, but I think with COVID-19, it wouldn't be as hard to change.
Yeah, I'm hoping courts are going to be a little more flexible, and I'm expecting that they will be because nobody really knows. So I think they'll be more flexible.
Yeah, I agree. I mean, you certainly have to categorize this last few months as being a catastrophic event. I mean, unemployment, businesses have been forced to shut down. So depending upon the type of business, for instance, a restaurant in Midtown is probably going to be in a far more difficult position than they were this time last year. I think that we're going to have to be more flexible with respect to valuation dates. Of course, depending upon the valuation dates really do depend upon the type of asset. So, when we're talking about a business, we really can't ignore the fact that people have been forced to shutter their doors. I don't see how a court could get away with ignoring that. It would make for a lot of appellate fodder if that were the case.
I imagine so.
Yeah. Now, one difference that we had talked about the other day when we were preparing for this talk was sort of some of the procedural differences between Pennsylvania, New York, and New Jersey. In Pennsylvania, there's a lot of duty upon the litigants and the attorneys to move a case forward, whereas my understanding in New Jersey and New York is that you are on a track with certain deadlines that the court imposes on you in a more formal way through a case management. Certainly that can happen in Pennsylvania, but it usually is a case that takes a different turn than most divorce cases where you don't have a case management order going into it. Do you anticipate having, Mark was saying that, it might be best to wait and see for many assets. Do you anticipate that being a problem in your states?
Stephanie, you want to answer first?
Yeah, so I'm also walking downstairs just to actually plug into the internet, just in case, because I keep saying. So in New Jersey, we have a case management conference pretty early on in the process, and we get a case management order, which tells us and directs like what kind of discovery we're going to have. So we're kind of forced to have a conversation, at the very beginning of the case to find out what kind of experts we're going to need, if we need to get a value of property, of houses and assets. If there's a business, we're definitely going to want to hire an expert to come in and value the business. So those things all are outlined in the case management order with timelines of when those things are happening. And I know from talking to you, Rebecca, that it's a little bit different as well, because in New Jersey, everything is in one docket under one filing. Whereas in Pennsylvania, I think they have different procedures happening at different times. Is that right?
That's right. So in Pennsylvania, we have, you file a divorce complaint in it, you can include account for custody. You could also even include, account for alimony support. In most counties, you have to also file a separate support filing, and that's going to travel on its own docket. So there's going to be a separate docket that deals with issues of child support, spousal support, alimony pendente lite, which is basically alimony while the litigation is pending. That's going to travel down its own track. Then we're going to have another track for custody, and that can be filed again within a divorce complaint, or it can be its own separate filing. And there's going to be dates for custody proceedings. And then there's going to be your divorce filing, division of assets and long-term alimony, as opposed to alimony pendente lite while a divorce is pending. And that's going to be its own separate track filing. And so you could certainly, for example, have a child support and alimony pendente lite agreement finalized, and not even moved your divorce case forward. You can have only done the support piece. Same thing. You could have a final custody agreement done outside of the divorce. You could even have a divorce done and never had addressed the issue of custody through the court. Maybe you didn't have a need to address custody. Maybe everything was working out fine. And then a couple years down the road, you decide to file for custody. So everything can travel on its own separate track in Pennsylvania.
Yeah, when we discussed that the other day, I remember Stephanie and I being relatively shocked because our process is a little bit more tightly reined in, not only by our judges, but also by statute. So for instance, in the state of New York, if you're going to file for your divorce based upon the irretrievable breakdown of the marriage, which in New Jersey is irreconcilable differences, you cannot get your actual divorce. You can't even get the judge to say judgment of divorce granted until you have resolved all of what we call the ancillary issues of your divorce, such as custody, child support, spousal support, visitation, and the big, aside from custody, the biggest thing aside from that is equitable distribution. And so we have what we call a preliminary conference, and that is your first court date, just like the case management conference in the state of New Jersey. That's your first court date. We talk about all of the assets. We talk about what we think the issues are going to be with respect to valuing the assets. We talk about whether the spouse, and let's go back to a business, whether the spouse who is the non-title party, who doesn't own the business, was active in the business. What was their level of activity in the business? We talk about whether experts are going to be hired. Are they going to be joint experts? And the experts that would be hired are people such as Mark and his company. So all of that is dealt with. Custody, all of it is talked about right in that preliminary conference order, as it is in the case management order, whether it's resolved or unresolved, and who's looking for what. And then our goal when we leave that preliminary conference is to know what assets have to be valued, such as the house, to know what dates have to be valued, because in the state of New York, if someone's name was added onto a deed, for instance, during the marriage, the entire property is marital property, but the person who owned the property and then put the spouse's name onto it after the marriage can claim a credit for the amount of value that property had on the day before they put their spouse's name on. And so that value has to be assessed. I know that it's not the same thing in New Jersey, and even though I started out practicing in New Jersey, once I came to New York, I was like, New Jersey's not fair.
That's one of the things we were talking about yesterday or today. I can't remember which, but I mean, in New Jersey, there's something that if you add a spouse to an account, if you add the spouse to your house, they presume it's a gift among spouses, essentially. But that doesn't, again, necessarily mean it's going to be a 50-50 split, but they're going to say, look, as far as we're concerned, you gave that to your spouse and you intended to gift that, half of the house or a portion of the house to your spouse. And now we need to figure out what amount to assign to the distribution of the asset. And we really then have to look at how long ago was that? Is this a 5-year marriage and you added the person to the house, and then like 5 months later they decided to file for divorce? They're really going to look at that asset and say, all right, he's had it for 20 years prior. They've been married for 5 years. You really get next to nothing for that house. But are we talking about a house that's been in the family for a long time, but then you've also been married for 20 years and you put your spouse on the house? Then you're looking more closer to 50-50 as far as a lot of the courts are concerned. So everything is really very fact sensitive.
Right. And that's to understand a lot of if you can't resolve your case, a lot of these issues are going to be dealt with in the discretion of the court.
Mm-hmm.
So there may be a circumstance where, even though New York State case law says that you can argue for your credit, right, for your premarital credit in the value of that home, for instance, there may be cases where the judge says, okay, well, for this reason or that reason, perhaps it's your behavior in the court case, perhaps it's that someone has diminished other assets. So these things are always moving targets, and they're going to be very heavily fact sensitive.
Mm-hmm. Yeah. Yeah, in Pennsylvania, the way we deal with like the issue on the house, it varies from county to county. Again, we might, for example, have a vanishing credit. One county that's outside of Pennsylvania, outside of Philadelphia, Montgomery County, we always see them do a 5% vanishing credit on a non-marital contribution to a house per year of marriage. And so 5 years of marriage, vanishing credit of 25% of what total amount was that's not marital. So that's one thing that we see, but that could vary. Again, you can walk over to Philadelphia, you may not see that same exact formulaic adjustment. It could be, that it's divided in some other proportion. So it doesn't always travel from county to county the way that we see addressing for issues such as that. But certainly there are some practice, tips, rules of thumb, things that you see in certain counties that you can use in your practice to value assets like that.
Yeah, and I mean, some counties are 5%, some counties are 10%. It does vary depending on what county you're in Pennsylvania.
So talking about business valuations, Mark, what are the ways that a business can be valued?
I mean, there's 3 primary ways. You have your asset base, which is what's there. Fire sale type of thing. If you're an asset heavy business, you have income. You analyze the income of the business for a period of time, and you base it on that, the cash flow that it derives. And then the third method is market value, looking at the market to see what similar types of companies are selling for. Those are the 3 major ways. You can blend the 2 together. Once you get into income method, there's also different methods within that on how we come up with numbers. There's discounted cash flows, weighted averages, and different methods that we use to value.
Is there one method that you find is better suited for, like, let's say we're talking about restaurants, because I know there's a lot of restaurants that have just completely, shuttered for the time being. So is there certain values that you would use for restaurants versus a clothing store?
Yeah, I mean, really what it comes down to is if there's a market out there for something, we try to base it on that first. That's usually the easiest and best. There's things out there that regularly trade hands. One of the examples that I always use is an insurance broker with a book of business. There's a standard for how that transitions from one person to another, and that's just the way it's done in the industry. When you get into like mom and pop businesses, if it's a one-off, something that's not common, you can't really look at the market that way. You have to get back into things and to look at the operations. If I'm going to step into that role of owning that business, what's it going to cost? What's my payback period? How long is it going to take me? And you have to manage the risks. Some businesses are riskier than others. Restaurant versus having a corner store where there's nobody else around you, versus having a car dealership, versus having a service station or something else like that. They all have different risks involved. and you have to weigh those risks to see how they translate. Some things might be riskier than others.
And with the valuation, and I'm sorry if I just cut me off if you guys have questions also, but does the valuations for the divorce context differ from like if you were trying to sell your business?
There's different contexts. When we get into the divorce context, there's other variables at play. In Pennsylvania, you have a lot of instances where you have unreported income or personal expenses running through the business that have to be translated out.
I like that, translated.
Well, it's really income. Some of it could be ordinary and expected, and it's part of the business, and that's just the way it is. But it does translate into personal income for the individual, such as a car or something like that. But they need that car. One of my favorite ones that I had in Jersey years and years and years ago, they had running through research and development the guy's 40-foot boat moored off of the Bahamas with the crew. That's not really a business expense, but it was there.
Yeah.
That is research and development. When you're getting a business ready for sale, typically what you do is you do the quote unquote clean. You give the person advice because business sales take time. It's not something that you just do instantly. It can take 18 to 24 to 36 months. And you do the supposed clean. You get in there, you clean it out. You get rid of the crap. You stop the credit cards with all the personal expenses. You get rid of the kids' cars and the tuition payments. You get rid of like the utilities for the summer house. Things like that. And then that way, when they do their due diligence, they realize that they're getting the right numbers. Divorce, we got to dig for that stuff.
Yeah.
If I'm on the business owner side, the guy who's running the day to day, we try to get down to everything because I don't want to be caught off guard. The last thing I want to be is on the stand deciding, saying, well, this is what it really is, and having the other spouse come into play and tell me that, oh, you missed, X, Y, and Z. It's really not a business expense, and when you have more income, there's more value. And it really is in that dependent spouse's benefit to have their own expert that does the due diligence and finds all these things because it's more money for them at the end of the day. So yeah, there's a big difference between doing a business for sale and doing a business for divorce purposes.
Yeah. When you were talking about digging for divorce purposes, I just kind of laughed a little bit because I'm sure we have this countless number of times where we've had these people who have these $1 million houses and cars and all of these toys and extra things. And then when you see their return, they say, well, I make $20,000 a year. And that's what my alimony should be based on.
And the house has no mortgage. It's worth over $1 million. They have no loans on the cars, and you're like, well, how, your last 10 tax returns showed $50,000 a year. Your kids are in private school. How are you doing this? And it is the reality of the beast. In my 20 years of doing this, I've had a handful of clean businesses, and I find that usually the more owners, the better. The cleaner it is because they don't want to screw around with equalizing everybody.
In the last 16 years, I've had one business, and he came into me and he was like, here's the expenses. And then, by the way, here's our cash log. And I already gave it to my wife. So we're like on the same page. I was, one time.
I had one with 4 brothers. And they were very competitive. They detailed everything. I mean, this is back when they would detail their phone records. Back when you had the individual charges for the phone calls. Like they would. That's how detailed they were. And we didn't have to adjust anything on that one. It was kind of interesting.
So speaking about this income, I mean, one of the other values of having a business evaluated is also to figure out what the actual income is, what the cash flow of the business owner is, not only the value of the business. Is that right?
Yeah, I mean, in Jersey, a lot of that stuff will come into play when you're formulating your case information statement. You're categorizing all the expenses and everything like that. You want to make sure all that stuff sweeps in. And in Pennsylvania, when we're doing the net income available for support, that all comes in. You got to look at the true cash flow to the individual to come up with those baseline numbers of what's available on a monthly basis.
Yeah. Now, one thing that we had talked about is that for businesses and some other assets, the best approach might be a wait and see approach. But for income available for support, there are some issues right now. Mark, do you have any sort of practice tips for us as attorneys in terms of, with someone who is self-employed, how to, look at changes for an income right now when everything is so unstable and some businesses might be closed?
There's two sides of it right now. You have the individuals that are getting the payroll protection loans that might be forgiven, hopefully forgiven. That's technically another asset that comes into play if it's forgiven later. If they're still operating on some level, that's one thing. If they're totally shut down and they need that loan to pay everything, that's something else. But I always stress on documentation. Start documenting things as early as possible, get things together and organize. In Pennsylvania, you talked about, the premarital aspect of things, of getting the value, and then, you get the date of marriage, date of separation. You have to remember, in Pennsylvania, the burden of proof is on the asset holder. If you don't come in with a value for date of marriage, nobody's required to give you one. You have to come up with something that's sound and logical. I'm always amazed at the clients that I have that have binders of bank statements, 401k statements, of brokerage statements. I had a 40-year marriage a couple of years ago. The wife had stuff going back to the 60s. Wow. It was just unreal. But I had one last year where it was a 30+ year marriage. Husband alleged to have come in with over $1 million. He couldn't support any of it. I mean, the best he could do was 2 years after the date of marriage. They gave him some credit, but they didn't do the increase in value. They just gave him a credit for the baseline that might have existed at date of marriage, and they had been separated for 6 years by the time they resolved everything. She rode the wave. The wife rode the wave on all that stuff and got the appreciation after the fact because he couldn't prove it. It's a hard thing, but it's something that people in Pennsylvania need to think about.
Yeah, in New Jersey, there's a presumption if it was acquired during the course of the marriage, there's a presumption that it's to be distributed, and the burden is on the person saying that it is an immune asset to prove that it's immune. So it's very similar where we're looking at that. You have to, if you say that this is a premarital asset, you have to prove what the dollar amount was as of the date of marriage in order to get that portion excluded. How is it in New York a day?
So if you have a business that was premarital in New York and you haven't dealt with it in a prenup, this is why prenups are very important. Not our subject, but
it's a good subject, though. It's related. I think that's worth mentioning.
It is related. Then the quest is going to be to try to figure out what the business was worth, if you can, as of the date of marriage. That is often a very difficult feat, depending upon how long you've been married. All right, because as Mark said, most people don't keep things like the woman in the divorce.
That was entertaining, though.
That's like a unicorn.
That was an absolute unicorn. I can't even get people to keep their bank statements for 2 years. So I don't know how this woman had all that stuff. That part of the asset is going to be separate property. Then you got to delve into figuring out what the appreciation was and whether, again, it was active appreciation versus passive. Obviously, if it's a business, it's most likely going to be active appreciation, unless the person who is the title owner is a silent partner who really does nothing with respect to the business. Right. That increase in value is going to be marital. And that's a very tricky analysis for us as attorneys to have to deal with, let alone having to deal with it as a CPA who's doing the forensics on it.
Mhm. Yeah. And there's also, if there's any commingling of marital funds to maybe inject some equity into the business at some point in time when it might have been going slowly. Those things we have to look at. Does that change the dynamic of whether or not it's premarital anymore? Or is it just the commingled money that was put in that we should take out and split? I mean, it depends on what the value of the business is. It really does, and it also really does have to increase in value during the course of the marriage. So if you have $100,000 business as of the date of marriage, and 5 years later you're still looking at $100,000 business, even if there was contributions during the course of the marriage, there's nothing to distribute because there's no increase in value, provided that, I mean, there's certain, with some exceptions. Rebecca, what about in PA?
In terms of the increase in value of I mean, well, there, we have the, although it may not seem fair that a passive asset, the increase in value is distributable, it does take away some of this tough work that you ladies are doing in New York and New Jersey to figure out what came from where, because, the increase in value is marital. And so we don't have to figure out where it came from. If it increased, it, is likely to be marital unless funds came like from a gift from a family member or something like that, where, money came in from the outside as a gift to one person or an inheritance.
If there was no increase in value in the business?
Then there's no marital value to it. It would be, same as any other asset that, that the value is the value and there's no increase.
And so in that situation, the real crux of the inquiry would be, what is the cash flow, to figure out what the owner's income is for support purposes.
Yeah, and you have to be careful with double dipping there. You don't want to double count something, the increase in value and the income for purposes of support. It really is two things. We try to come up with a baseline. When we do valuations, one of the things that we adjust for is normalized income. What is the salary that person should be taking? And that's what we use in the valuation. And then when we turn around and do support, if it's spousal support, we use that normalized income number for the calculation of support. And then the real income goes into the child support calculation.
Right. Mark, can you talk about that double dipping concept? That's a concept for us in New York. We call it the mixed baron concept, based upon the case that talks about double dipping. Can you talk a little bit more about what that means? Because a lot of people don't understand that concept of double dip. They say, okay, here, I want my share of the value, which, quite frankly, in my county, it's very hard to even get into the two digits when we're talking about distributing a non-titled spouse's interest in the business if that non-titled spouse was also not active in the business. It's hard to get into the double digits in that situation.
Yeah,
so
I mean,
for that value plus all of the money on alimony or maintenance.
Yeah, I mean, there's really two realms. So you normalize the income for the individual. You say, okay, if I were to take this company, remove you and bring somebody else in to do your role, whether it's sales, overall management, whatever it is, what would I have to pay that person? And then we do a reasonable salary for that person, and that's what they should be getting. And we say that anything above and beyond that is income to the business for their efforts. And when you do a business valuation, typically if you're doing an income approach, you're spinning that income number into a value. So if the earnings of the business are another $500,000 a year above and beyond what that person's salary would be, if normalized, you can't use that to calculate support, because that person's already getting a ratio of that number, a multiple of that number in cash and in kind, distributions when they settle everything out. So you can't have it both ways, if that makes sense. You have to really have the two buckets and separate them.
I think
Because if you mix them together, you're getting the benefit of the income stream in your asset division, and you're getting the benefit of that income stream in your support payments.
And there is the double dip, right? Mm-hmm.
Yeah.
Yeah.
Do you have the same issue? Do you have the same issue in New Jersey, Stephanie, about the double dip? And what have your experience has been explaining this to your clients?
So we usually talk about, from the very beginning, I try to talk about the concept that there's two separate things that we have to figure out. And I think people get confused when they say, here's a business, we need to value it, I want a piece of the business. They're thinking about it in terms of just one, linear resolution to that. And I try at the very beginning to say, okay, well, we got to figure out two things. There's really two separate things. And I want to make sure you understand that there's a cash flow component, and then there's the actual value of the business. So I try to get them to understand that language early on, so there's not any confusion as we go forward and try to resolve their case, and they become disappointed. And usually in those cases, I mean, we're getting an expert anyway, so I'm having them meet with the expert, and we might need two separate reports, and they already understand going in, that's why.
Yeah, that's always to have that interaction with the expert is sometimes invaluable.
Mm-hmm. Yeah, I mean, depending on the case and the circumstance. So I've sometimes when I represent the person who does not own the business, you want them to sit with the expert early on just to kind of explain the concepts in a way that's not me advocating for them, because that also can become a problem, because I'm your advocate, but I also need to explain to you these concepts. And if we can rely on a third party expert to do that, all the better.
Mm-hmm.
Yeah, and a lot of times hearing that outsiders' information, their perception of things, what they think they know, how things work, what they see, it provides a lot of information for us because we want to hear that stuff before we go in and interview the business owner, so that we can get a little bit more of an idea of how things work. Are they really working 40 hours a week, or are they doing 15 and they're out in the golf course the rest of the time? Are they really working 80 and they're swamped? You want to really have an understanding of how involved that person and how integrated they are to the day-to-day operations.
And Mark, do you find that you're usually jointly retained or retained by one party?
I don't like to be jointly retained. Honestly, it happens sometimes if the parties are getting along and they're in a mediation situation and everything's fine and they're on the same page about everything, I don't mind. I don't want to get caught between two sparring spouses, one who wants me to investigate something and the other one who won't give me access if I'm joint, because that's really a conflict of interest, and I tend to avoid that. I'd rather be advocating for a single person. It's easier.
And then you run into the difficulty of payment, because you don't always have the money to pay for two separate experts, unfortunately.
And that's the nature of the beast. Really, in divorce cases, I've had many cases that, where you give somebody the benefit of the doubt for a while, and you take what you can along the way, and then you get the lump sum at the end. And some of them last longer than others. When I was at my last firm, we had a case that lasted 10 years. You get the ones that last 4 or 5 in this realm. I mean, if you have complicated cases with multiple businesses, they can take time to get through everything.
Even some of the smaller businesses take quite a while to get through. It depends on the records. I
always tell people the hardest part is discovery, getting the information, the dribs and drabs, the gaps, the missing pages. That's either the hardest or the easiest part of the case. I can waste more. I mean, you can spin out of control on discovery if you have an opposing party that is not cooperating or piecemealing things.
And Stephanie and Ade, given in New York and New Jersey that your cases start with some sort of case management where you identify the experts, do you find that your experts in New York and New Jersey are more often jointly retained?
Yes. In New York, the experts are more often jointly retained. And then, so what we do is we review that joint report, And then very rarely, if a spouse really just can't get on board with what these numbers are, we're in the situation where we then have to hire somebody as a independent, and that's when you really start to get into some funky business, because that money is being spent, and these evaluations are not cheap, because things that people like Mark do are not simple. They are not simple. Getting into the weeds and understanding the IRS regs and what can be written off and what can't be written off, and looking for the red herrings. That type of knowledge is honed, just like matrimonial lawyers, over time and experience, and through study. And so, if you cannot get on board for whatever reason, and hopefully they are legitimate reasons, right? Because I would counsel my client, that if there are some things that we can work on and agree upon, to either say, okay, well, this deduction shouldn't be made, or we'll add this back in, then maybe we should do that with our adversary instead of hiring another expert and going through all of this trauma again, because it is traumatic to have all the books opened up and dealing with this and have multiple depositions and
I mean, I've worked all over Pennsylvania and New Jersey, and I'll say that there are some experts that play well in the sandbox together, that add value to each other and work well together. And we don't always catch everything, and that's kind of why I like having an opposing party, because it kind of makes me work harder to do everything. And when you have an opposing expert that you play well in the sandbox together, it's a lot easier. In certain areas that don't play well, and usually go too far advocating and cutting corners and things like that, and it's a different game then.
Like playing with percentages and stuff.
Yeah, we know about playing in the sandbox.
When you're looking at business valuation, there's certain things that are just valuator discretion. When you're looking at risk factors, when you're looking at other percentages that play into how that value is calculated, there's games that can be played there. Tax rates, things of that nature, that I like having somebody else sanity check.
You know what? I have a question going off of businesses. I know the answer in New Jersey. Rebecca, are degrees and licenses valued in divorces in Pennsylvania?
No, not in that way. And what we see often is, like with student loans, for example, one person might have a bunch of student loans that they acquired during the marriage. Technically, it's marital property, but this is where we go back to equitable distribution. Almost always that goes with the person who got the education. Now it's gonna, might come into play with alimony, and one of the alimony factors, that if one person was supporting the other while getting a degree, we look at a number of different factors. If that increased their earning capacity, maybe we look at it in terms of how alimony awarded or what it's going to be equitable. But in terms of the actual assigning of value to it, and I'll let Mark speak to that as well.
I mean, in my realm of things, I know when I was in Jersey and Pennsylvania, we'd hear about New York states and the valuing licenses, and I'm like, I'm never moving there. I wondered if that was still the case or not, but
it's not.
It really does translate into earning capacity when you're figuring out a reasonable compensation. So, I mean, it does play into that a little bit, but it's not a separate value. It's not a separate item on the asset chart.
So our law, the case that precipitated this whole thing was called O'Brien versus O'Brien. Had to do with a lawyer, by the way, and that was the case that said, "Yep, that law degree you have up there, or your CPA, your certificates, your whatever you get, that's going to be valued, and we're going to figure out not only what your enhanced earnings are, but what the value of your license is by virtue of the enhanced earnings, and we're going to distribute that." Our law changed in 2015. So if you're not getting divorced because you don't want that license hanging on the wall to be, that's no longer an impediment. But yes, that I think the last case I did dealing with the valuation of a license had to do with a neonatologist who was at the end of his career. He was in his late 60s, and his wife was able to receive almost $100,000
Wow.
in equitable distribution as what we call a distributive award, which is a lump sum of money that goes to a spouse. That was good.
Wow.
And
That
then
is so interesting. I would not I would not know
It
how to
almost
assign
sounds
a
like a
value
double dip.
outside of what the earning potential is.
that's exactly the way you do it. You do the earnings potential and you project it out based upon the person's life expectancy. And then there's some discounts involved.
Yeah, but it
Not
seems
like-
challenging with like the interplay with alimony.
And the
And
risk of double dipping and
Yeah.
like yeah, very interesting.
But it's out the window, huh?
I'm surprised it lasted till 2015.
It sure did. It lasted at least, I think it was over 20 years. I can't remember the year of the O'Brien case, but it was a very long time that this
Wow.
all lasted. Mm-hmm.
Interesting.
Yeah. So it's funny because my husband, I'll give you a personal anecdote. My husband had asked me to marry him while I was in law school. I was like, absolutely not. You can wait a few years, bud. Aside from that, sorry. Can't do
You're
it.
paying attention to law school.
I was paying attention. Good. I was taking notes.
We should talk about prenuptial agreements another time.
I know.
So
For sure.
seen directly with respect to any of the valuations that you're doing or we're close to finalizing or anything like that, that there has been any kind of COVID related impact in your cases?
Yeah, I mean, a lot of stuff just went on hold. I have a case right now where they have a bunch of car dealerships and you know, the owner is claiming everything shut down, you know, all done. But, you know, you go to the website, our service centers are open, you know, it's like, well, which is it? So we're just kind of in a wait and see mode on almost everything. I have spouses who are putting pressure on to take advantage of the situation, to try to get it to settle now. But I think that the general gist is let's just ride this out. We can't do in-person meetings. We can't get in work. You know, you can't do your day of arbitration if that's the realm or mediation if that's the way that you're going. Let's just hold off for a couple months and do a wait and see what happens when it comes around.
And how is this affecting how you would normally do evaluation? For example, if it might be that there's limited ability to go places, are you seeing that that's going to impact you where you may not be able to go to a facility because they're limiting their contact? Or
yeah, I mean that's part of it. You know, part of the wait and see is you want to interview the people. You want to get down. We've had some phone interviews where you have that, but it is what it is. You do what you can. You know, I would rather see people and tour facilities and see the business operations and things of that nature. It's a little bit different. But yeah, you do what you can. Most are waiting to pick up later. And who knows how, I mean, things might change, you know, if this does last longer, if we go into a second shutdown, who knows?
Is there any consensus, and I'm hearing that there might not be, but of what or how you're going to value things in the future, like in the short-term future? So or is there talk about maybe cutting these last like 3 months and kind of just essentially
you're
ignoring them as an anomaly?
You know, if you're doing it, what would be an income approach, you can't just take the last 3 years and normalize it. You're going to have to you're going to have to do a discounted cash flow of expected income, you know, because they're going to have a ramp up period. They're going to have a transition period. They're going to have to hire people back. They're going to have to retool depending on the type of business it is. They're going to have that comeback period, and history isn't showing that. It's going to be different. So you're going to have to recalculate things and do a different approach.
Do you have suggestions for people who are impatient? There are people who are wanting to get divorced that they don't want to wait and see. What would your advice be?
as with everybody, I'm sure you tell them, let's get an offer. If you're the business owner and you want it done, make an offer. We'll evaluate it, see how much we'll run our own numbers. If I'm representing the business owner, I'm going to say, well, if you want to get this done, let's run some numbers. Let's see what makes sense and see what you're comfortable with, and let's make an offer. And if I'm on the other end, if I'm the non-business owner, I'm gonna say, let's get something on the table from them, and see how far off we are. If they can come to terms on something, we can get numbers that work globally. We can get it done. But if like, I hate using this, but if you're the non-moneyed spouse in Pennsylvania, ride the wave, get the support payments, hold out. That's usually what I tell people, because it's in your best interest, because the clock starts again on alimony when you get divorced. You can get the alimony pedente laete for a period of time, and if the other spouse isn't fighting it, might as well just wait.
Yeah. I just lost my question.
Sorry.
And it's something to do with before alimony. Then I was like, oh, that's interesting. It's been a really, really long week today. It feels like this was the entire week today.
I hear you. It's been an interesting day. This has been the highlight of my day, though, and I've been really impressed with and happy to meet Mark.
Me too. I'm glad you jumped on with us.
Yeah, it was very helpful.
It was. Does anybody have any final words? We are at the top of the hour. Nope. Okay.
No.
Well, we're going to sign off. Oh,
we've been scrolling stuff, so if anybody has questions for any of us, I think the emails have been scrolling randomly. So if you need to contact us, it's a great way.
Yep, at the beginning. And we can also put all of our contact information. And I think all of our contact information is in the event page, but we'll make sure we put your contact information as well, Mark, in the event page. And I did scroll everybody's website and phone number as we were kind of going through this. So
yes, thank you.
Thanks. Have a great day, everyone.
Yeah, thank you for joining us.
Thanks, everybody, for watching.
Bye.
Bye.
Bye.